Thank you for visiting the Miltenberger Law Offices YouTube channel and our website. We are a proven criminal defense law firm in Nebraska with over 1,000 cases handled and over 12 years of combined legal experience. Our firm has created these audio articles to help educate you on your rights, protect your freedom, and help you achieve the best solution for the charges you are facing. If we are hired for your case, we will never back down, no matter the odds. Domestic violence lawyer in Omaha, Nebraska. Domestic violence charges in Omaha can move fast. One call to the police, one argument, one accusation, one misunderstanding during a heated moment. And suddenly, you may be dealing with an arrest, a no-contact order, bond conditions, court dates, firearm restrictions, and criminal charges that can affect your family, career, reputation, and future. That escalates quickly. At Miltenberger Law Offices, we represent individuals facing domestic violence and domestic assault charges throughout Omaha, Douglas County, and across Nebraska. Whether you are accused of threatening an intimate partner, causing bodily injury, violating a protection order, or committing a felony-level domestic assault offense, we carefully examine the facts, challenge the evidence, and work to protect your rights. If you have been arrested, charged, or believe you are under investigation for domestic violence in Omaha, call 402-217-2267 or contact Miltenberger Law Offices online to speak with an experienced Omaha criminal defense attorney. Because an accusation is not a conviction, and the police report is rarely the whole story. What is domestic violence in Nebraska? Domestic violence is not a single charge in every situation. Instead, domestic violence cases in Nebraska may involve several different criminal offenses, depending on the relationship between the parties, the alleged conduct, the injuries involved, and whether prior convictions exist. Many Omaha domestic violence cases are charged under Nebraska's domestic assault statute. Nebraska Revised Statute Section 28-323. Nebraska law defines domestic assault in varying degrees based on whether the allegation involves bodily injury, threats of imminent injury, a dangerous instrument, or serious bodily injury. Domestic violence cases may involve allegations between spouses, former spouses, people who have a child together, current or former dating partners, people involved in an intimate relationship, household or family-related situations depending on the charge involved. These cases are often emotionally complicated. They may involve alcohol, custody disputes, divorce issues, financial stress, conflicting stories, or allegations made during one of the worst moments of someone's life. That does not mean prosecutors can skip the burden of proof. Types of domestic violence charges we defend in Omaha. Miltenberger Law Offices represents clients facing a wide range of domestic violence-related charges in Omaha and throughout Nebraska. Third-degree domestic assault. Third-degree domestic assault is one of the most common domestic violence charges in Nebraska. Under Nebraska Revised Statute, Section 28-323, third-degree domestic assault may involve allegations that a person intentionally, knowingly, or recklessly caused bodily injury to an intimate partner or threatened an intimate partner with imminent bodily injury. Nebraska classifies a first offense as a Class I misdemeanor, but prior convictions can elevate the charge to a felony. These cases may involve allegations of pushing, shoving, slapping, punching, grabbing, threats of imminent harm, arguments that allegedly escalated into physical contact. Second-degree domestic assault. Second-degree domestic assault is more serious and is generally charged when prosecutors allege bodily injury involving a dangerous instrument or serious bodily injury caused recklessly with a dangerous instrument. Under Nebraska law, second-degree domestic assault is generally a Class 2A felony, with increased penalties if the person has prior qualifying domestic assault convictions. A dangerous instrument can be broader than people expect. Depending on the allegations, prosecutors may point to objects such as firearms, knives, glass bottles, vehicles, tools, household objects, other items allegedly capable of causing serious injury. In other words, something does not have to be designed as a weapon for prosecutors to argue it was used as one. First-degree domestic assault. First-degree domestic assault involves allegations that a person intentionally and knowingly caused serious bodily injury to an intimate partner. This is a very serious felony offense. Nebraska classifies first-degree domestic assault as a Class 1D felony, with enhanced penalties for individuals who have prior qualifying convictions. First-degree domestic assault cases may involve allegations of broken bones, serious head injuries, severe lacerations, injuries requiring surgery, permanent impairment, disfigurement. Because the stakes are high, these cases require a careful review of medical records, photographs, witness statements, body camera footage, 911 recordings, and expert evidence when necessary. Assault by strangulation or suffocation. Strangulation allegations are treated especially seriously by prosecutors. Under Nebraska Revised Statute Section 28-310.01, assault by strangulation or suffocation generally involves knowingly and intentionally impeding another person's breathing or blood circulation by applying pressure to the throat or neck, or by covering the person's mouth and nose. Nebraska law states the offense may be committed even if no visible injury resulted. That last part matters. In many cases, prosecutors pursue strangulation charges even when there are no obvious marks, bruises, or photographs showing visible injury. Under Nebraska law, assault by strangulation or suffocation is generally a Class 3A felony, but it may become a Class 2A felony if a dangerous instrument was used, serious bodily injury resulted, or the accused has a prior qualifying conviction. Protection order violations. Domestic violence cases often involve protection orders or no-contact orders, including violation of a harassment protection order, Section 28-311.09. Nebraska law makes it a crime to knowingly disregard the terms of a court-issued harassment protection order. Prohibited conduct may include contacting, threatening, harassing, or otherwise violating the conditions of the order after receiving legal notice. A violation is generally classified as a Class 2 misdemeanor. Violation of a domestic abuse protection order, Section 42-924. Nebraska law treats violations of domestic abuse protection orders seriously. Knowingly disobeying the conditions of a protection order, including contacting the protected person, approaching prohibited locations, or violating other court-imposed restrictions, may result in criminal prosecution. A first offense is generally a Class 1 misdemeanor, while a subsequent conviction may be elevated to a Class 4 felony. Once a court order is in place in Omaha, violating it can create a separate criminal problem. That can happen through phone calls, text messages, social media messages, emails, showing up at a home or workplace, contact through friends or family members, accidental contact that is handled poorly. Many people think, but the other person contacted me first. That may matter legally. It may also not save you from being arrested. If there is a no-contact order, protection order, or bond condition in place, follow it carefully and speak with an attorney before communicating with the protected person. Child abuse allegations connected to domestic violence cases. Some domestic violence investigations also lead to child abuse allegations, especially when children were present during an alleged incident or prosecutors believe a child was placed at risk. Nebraska Revised Statute Section 28-707 addresses child abuse and includes conduct that knowingly, intentionally, or negligently causes or permits a minor child to be placed in a situation that endangers the child's life or physical or mental health. These allegations can create serious criminal consequences and may also affect custody, parenting time, and family court proceedings. Abandonment of a spouse or child. Nebraska law makes it a criminal offense to knowingly abandon or fail to support a spouse, child, or dependent stepchild. According to Nebraska Revised Statute Section 28-705, the offense is generally classified as a Class 1 misdemeanor. For purposes of the statute, a child includes an individual under the age of 16, and a failure to provide support for 3 or more consecutive months may serve as evidence that the abandonment was intentional. Domestic violence charges involving firearms. Domestic violence allegations can also create firearm-related issues. Depending on the case, a person may face restrictions on firearm possession, surrender requirements, or additional weapons charges if prosecutors allege a firearm was used, displayed, or possessed unlawfully. If your case in Omaha or anywhere else in Nebraska involves a firearm, it may also be important to review our page on weapons and firearms charges. Domestic violence resources in Omaha, Nebraska. Nebraska Domestic Assault Statute. Web page, the Nebraska Legislature's official statute defining first, second, and third-degree domestic assault and related penalties. Nebraska Judicial Branch Protection Order Information web page provides general information about protection orders, including domestic abuse and harassment protection order procedures. Douglas County Domestic Violence Prosecution Unit. Domestic violence cases in Omaha are handled aggressively by the Douglas County Attorney's Office through its specialized Domestic Violence Prosecution Unit. Working alongside law enforcement, victim assistance programs, and other community partners, the unit seeks to investigate allegations, prosecute offenders, protect victims and their families, and reduce repeat acts of domestic violence. Understanding how the prosecution approaches these cases highlights why it's important to work with an experienced Omaha domestic violence defense attorney as early as possible. Cornell Legal Information Institute, Self-Defense. Overview. Educational overview of self-defense principles that may arise in assault and domestic violence cases. Can the alleged victim drop domestic violence charges? This is one of the most common questions in domestic violence cases. The answer is usually frustrating, not by themselves. In Nebraska, domestic violence charges are prosecuted by the state, not by the alleged victim. Once police make an arrest or prosecutors file charges, the complaining witness does not have complete control over whether the case continues. The alleged victim may want the case dismissed. They may refuse to cooperate. They may say the situation was exaggerated. They may even admit they were wrong. Prosecutors may still move forward using other evidence, including 911 recordings, police reports, body camera footage, photographs, medical records, text messages, witness statements, statements made at the scene. In other words, once the legal system gets involved, it does not always politely excuse itself just because both people want to move on. Nebraska domestic violence penalties at a glance. The penalties for domestic violence charges in Nebraska depend on the specific offense, the alleged injuries, prior convictions, and whether weapons, strangulation, children, or protection orders are involved. Domestic violence offense. Third-degree domestic assault. Nebraska Statute, Section 28-323. Classification, Class 1 misdemeanor. First. Felony for certain repeat offenses. Potential penalties/notes. May involve causing bodily injury or threatening an intimate partner with imminent bodily injury. Domestic violence offense. Second-degree domestic assault. Nebraska Statute, Section 28-323. Classification, Class 2A felony. Enhanced penalties for certain repeat offenders. Potential penalties/notes. Typically involve serious bodily injury or use of a dangerous instrument. Domestic violence offense. First-degree domestic assault. Nebraska Statute, Section 28-323. Classification, Class 1D felony. May be enhanced for prior qualifying convictions. Potential penalties/notes. Allegations involving intentionally causing serious bodily injury to an intimate partner. Domestic violence offense. Assault by strangulation or suffocation. Nebraska Statute, Section 28-310.01. Classification, Class 3A felony. May become Class 2A felony. Potential penalties/notes. No visible injury is required. Penalties increase when serious bodily injury, a dangerous instrument, or prior convictions are involved. Domestic violence offense. Violation of a harassment protection order. Nebraska Statute, Section 28-311.09. Classification, Class 2 misdemeanor. Potential penalties/notes. Knowingly violating the terms of a court-issued harassment protection order. Domestic violence offense. Violation of a domestic abuse protection order. Nebraska Statute, Section 42-924. Classification, Class 1 misdemeanor, first. Class 4 felony, subsequent offenses. Potential penalties/notes. Knowingly violating a domestic abuse protection order after receiving notice. Domestic violence offense. Child abuse. Nebraska Statute, Section 28-707. Classification varies. Potential penalties/notes. Classification depends on the alleged conduct, resulting injuries, intent, and surrounding circumstances. Domestic violence offense. Abandonment of a spouse or child. Nebraska Statute, Section 28-705. Classification, Class 1, misdemeanor. Potential penalties/notes. Knowingly abandoning or failing to support a spouse, child, or dependent stepchild. Failure to provide support for 3 consecutive months may be evidence of intent. Domestic violence offense. Domestic violence involving firearms. Nebraska Statute, various Nebraska and federal statutes. Classification varies. Potential penalties/notes. May result in separate weapons charges, firearm surrender requirements, loss of firearm rights, and federal firearm restrictions following certain convictions or protection orders. Disclaimer: domestic violence penalties in Nebraska depend on numerous factors, including the specific allegations, the severity of any injuries, prior convictions, the use of a dangerous instrument or firearm, protection order violations, and other aggravating circumstances. This table provides a general overview and is not legal advice. Common defenses to domestic violence charges in Omaha. Every domestic violence case is different. Some are supported by strong evidence. Others are built on assumptions, incomplete stories, or statements made during highly emotional moments. Common defenses may include self-defense. Not everyone accused of domestic assault was the aggressor. If you acted to protect yourself from unlawful force, self-defense may become a central issue. False or exaggerated allegations. Domestic violence accusations sometimes arise during breakups, custody disputes, divorce proceedings, jealousy, retaliation, or heated arguments. That does not automatically mean the allegation is false, but it does mean the context matters. Lack of intent. Some domestic assault charges require prosecutors to prove a specific mental state. An accident, misunderstanding, or unintentional contact may not support the charge filed. No bodily injury or insufficient evidence. Prosecutors must prove the elements of the offense. If the evidence does not establish injury, threat, intent, or the required relationship, the case may be weaker than it first appears. Conflicting witness statements. Domestic violence cases often involve two very different versions of the same event. Body camera footage, 911 calls, text messages, photographs, and independent witnesses can become critically important. Constitutional violations. If law enforcement violated your rights during questioning, arrest, or evidence collection, certain statements or evidence may be challenged. Failure to prove the relationship element. Domestic assault charges require a qualifying relationship under Nebraska law. If prosecutors cannot prove that element, the domestic assault charge may not fit the facts. What should you do after a domestic violence arrest in Omaha? What you do in the hours and days following a domestic violence arrest can have a significant impact on your case. It's understandable to feel overwhelmed, frustrated, or eager to explain your side of the story, but certain decisions can make an already difficult situation even more complicated. Taking the right steps early can help protect your rights, preserve important evidence, and avoid mistakes that prosecutors may later use against you. The Miltenberger Law Domestic Violence Defense Team in Omaha suggests you take the following steps. Step 1. Exercise your right to remain silent. It is natural to want to explain yourself, especially when you believe the accusation is wrong. Unfortunately, statements made to police can be misunderstood, misquoted, or used against you later. Provide basic identifying information if required, but avoid discussing the allegations until you speak with a defense attorney. Step 2. Do not contact the alleged victim. If there is a no-contact order, protection order, or bond condition in place, follow it exactly. Do not call, do not text. Do not message through social media. Do not ask a friend to just pass along one thing. That one thing can become a new criminal allegation. Step 3. Preserve evidence. Save anything that may help explain what happened, including text messages, emails, call logs, photos, videos, social media messages, medical records, witness contact information, location data. Do not delete anything. Context matters. Step 4. Follow all court orders. Domestic violence cases in the Omaha area often involve strict bond conditions. Violating them can make the case worse and may result in additional charges or being taken back into custody. Step 5. Stay off social media. Do not post about the case, not vaguely, not sarcastically, not just to tell your side. If you would not want a prosecutor reading it in court, Do not post it. Step 6. Contact a domestic violence lawyer immediately. The sooner an Omaha domestic violence defense attorney becomes involved, the sooner steps can be taken to preserve evidence, protect your rights, review court orders, and begin building your defense. Frequently asked questions about domestic violence charges in Omaha. Is domestic violence a felony in Nebraska? Answer: it can be. Some domestic assault charges are misdemeanors, while others are felonies. The classification depends on the degree of the offense, prior convictions, injuries involved, use of a dangerous instrument, and other facts. Can domestic violence charges be dropped if the alleged victim does not want to testify? Answer: not automatically. Prosecutors decide whether to continue the case. They may rely on 911 calls, body camera footage, photographs, medical records, and other evidence even if the alleged victim does not want to participate. Can I go home after a domestic violence arrest in Omaha? Answer: it depends on the bond conditions and whether a no-contact order or protection order is in place. Do not return home or contact the protected person unless you are certain the court allows it. What if I acted in self-defense? Answer: self-defense may be a strong defense in some Omaha domestic violence cases. Evidence such as injuries, witness statements, video footage, text messages, and prior communications may help show what actually happened. What if there were no visible injuries? Answer: some charges may still proceed without visible injuries, especially when threats or strangulation allegations are involved. However, lack of visible injury may still be important when challenging the government's evidence. Will a domestic violence conviction affect my gun rights? Answer: it can. Domestic violence convictions, protection orders, and related restrictions may affect firearm possession under state or federal law. If firearms are involved, speak with an attorney immediately. Should I talk to the police if I know I did nothing wrong? Answer: not before speaking with an Omaha domestic violence defense attorney. Innocent people can still make statements that are taken out of context or used against them later. When should I hire a domestic violence lawyer in Omaha? Answer: immediately. Early legal representation may help preserve evidence, protect your rights, review court orders, and prevent avoidable mistakes. Why choose Miltenberger Law to defend a domestic violence charge in Omaha? Domestic violence cases are rarely simple. There may be 2 versions of what happened, sometimes 3. Sometimes the evidence tells a very different story than the initial accusation. At Miltenberger Law Offices, we do not treat the police report as the final word. We review the facts, examine the evidence, identify weaknesses in the government's case, and help clients understand what they are facing. Because serious allegations deserve serious scrutiny, and your future should not be decided by one side of the story. Talk to a Miltenberger Law Omaha domestic violence attorney today. If you have been arrested, charged, or believe you are under investigation for domestic violence in Omaha or anywhere in Nebraska, do not wait to protect your rights. The earlier an experienced defense attorney becomes involved, the more opportunities there may be to preserve evidence, address court orders, and begin building your defense. Call 402-2172-267 or contact Miltenberger Law online today to schedule a confidential consultation with an experienced Omaha domestic violence lawyer. Because one accusation should not define the rest of your life. Miltenberger Law Offices is a leading criminal defense law firm serving the entire state of Nebraska. We are headquartered in Omaha and serve Douglas County, Lancaster County, Lincoln, Sarpy County, and all of Nebraska. We look forward to helping you with your criminal defense attorney needs.